Hi everyone, welcome to Beyond the Evidence. This is the channel where justice matters. My name is Marv. I am a true crime fanatic, and I love to dig deeper into the mysteries of unsolved cases. Join me as we search for missing persons, uncover the clues in unsolved murders, follow along with jury trials, and we'll be a voice for the voiceless. I'll share with you the facts, the theories, the clues, the evidence, and the controversies that surround these cases. This is Beyond the Evidence. Hello, everyone. Welcome back to Beyond the Evidence. I'm Marv, your host, and tonight we are continuing with part 2 of Lessons Learned from a Child Predator. First, before we start, I just want to say thank you for the many messages of support that I got last night on last night's live. For everyone who checked on my mental health, made sure I was okay. I am okay. It's hard to read through something like that last night. One of the hardest things I've ever had to read. Tonight it'll be a little bit easier, even though it's still the same subject. I'm going through some of the other documents from this case. We're going to have some discussion, and I'm going to give you some tips on what to look for, what resources to investigate as a parent so you can help safeguard your child. So with that being said, I am going to show some documents tonight that I'm reading from. I'm able to do that. And I'm starting with the response to motion to sever, because people had questions why counts 1 and 3 were separated from counts 4 through 48. So I wanted to answer that for you all. So we have a response. The defense put in a response or a motion to sever, and this is the prosecution's response to that motion. Comes now the people of the state of Colorado by and through Seth D. Ryan, District Attorney for the 7th Judicial District State of Colorado, by and through his duly appointed Deputy District Attorney, Aubrey Thompson, hereby submits the following response in opposition to defendant's motion to sever for the following. Defendant by and through his counsel seek to serve counts 1 through 3 from counts 4 through 48. Defendant argues the counts charging the defendant with sexual exploitation of a child would be evident of prior bad acts as defined by CRS 404B and would be prejudicial to the defendant. The court is afforded broad discretion in determining whether to order separate trials. The people maintain that separate trials are not warranted in this instance. The people have an obligation under both Colorado R, Criminal P, SA, and CRS 18-1-408-2 for compulsory joinder of offenses that occur as part of the same criminal episode. In Core versus District Court, the Colorado Supreme Court held that the terms...
Could you try again?
Sorry about that. The Colorado Supreme Court held that the term same criminal episode is sufficiently broad to include offenses that occur at the same time and location, regardless of whether these offenses are otherwise related to each other by some underlying purpose or scheme. And it lists another case. The offenses were speeding and possession of marijuana. In the instant case, defendant repeatedly texted blank or redacted and regarded redacted minor's son and was accessing the image and videos in count 4 through 48 during the date range charged. The text included the defendant's physical description of the minor, his desire to be close to the minor, and the references to other criminals whose victims were minors. The people have the burden to prove a mens rea of knowingly and true threat regarding counts 1 through 3. The images and videos on the defendant's phone, in conjunction with his behavior toward the redacted family, are relevant evidence of the defendant's state of mind and intentions during this time. All the offenses occurred during the same criminal episode, as that term is defined. As such, they are properly joined. And then the defense or the people submitted the following exhibits as evidence. There was images, there was videos, and there were texts. An appropriate limiting instruction to the jury will also remove any possible undue prejudice. There being no actual prejudice to defendant, having a single trial further the joinder policy of judicial economy. It is more efficient and less burdensome for all involved to have a single trial for multiple offenses rather than a separate trial for each offense. In the alternative, if the court deems the evidence of the counts to be too prejudicial in conjunction with the balance of counts, the people respectfully the counts be bifurcated rather than severed. For the reasons stated above, the people assert that the risk of substantial prejudice is low and a single trial for both all counts is appropriate. So, why did the counts get severed? Well, the judge felt that by having all the counts together, the stalking, intimidation, and the exploitation, it would be too prejudicial. So therefore, the judge granted the motion to sever, meaning counts 1 through 3 would be tried separately for counts 4 through 48. So just so everybody knows, tonight chat is on slow mode. I put it on 60 seconds. That way the mods have an easier time, and I might be able to catch some comments tonight as I'm reading. So I wanted to start with that so that you guys know, because it was questioned. I went back through the chat last night, and that is one of the questions that I saw. So I wanted to bring on that document, explain why the counts were separated. So now I am going to find my next document here. We don't need to read through the motion for jury questionnaires. Okay. The next document is going to be motion to suppress evidence obtained outside the scope of his involuntarily given consent. This was filed March 11th, 2024 at 9:30 p.m. People of the State of Colorado versus Donovan Boudreaux. And there are pictures with this one. Donovan Boudreaux, through counsel, moves to suppress all statements obtained in violation of the 5th, 6th, and 14th Amendments to the United States Constitution and Article 2, Section 16, 18, and 25 of the Colorado Constitution as grounds. On March 20th, 2023, at approximately 8:30 p.m., Donovan Boudreaux is handcuffed and marched into an interrogation room at the Montrose Police Department. And this is the picture of him entering the interrogation room. Mr. Boudreaux is subsequently interrogated by Detective Graves for 2 hours. At that point, he's handcuffed. At that point, he remains in the interrogation room. At one point, he's allowed to speak with an attorney, a friend, his father, his mother, or anyone other than Detective Graves. It appears officers remain outside of the room throughout the interrogation. Once Mr. Boudreaux is seated and the officers who brought him in have left, Detective Graves says, "You're obviously in custody, so I have to advise you of your rights." She proceeds to read Mr. Boudreaux his Miranda rights. Mr. Boudreaux claims to understand and signs the waiver of rights. Detective Graves proceeds to ask Mr. Boudreaux questions for approximately 2 hours. Let's see. During the interrogation, Detective Graves tells Mr. Boudreaux that bond will be set by the judge and that bond will determine whether he has to stay in jail or is released. Detective Graves tells Mr. Boudreaux that if he talks to her, she can explain to the judge that he's not a threat and a reasonable bond should be set. On the other hand, if he doesn't speak with her, she may assume he's a serial killer. Approximately an hour and a half into the interrogation, Detective Graves tells Mr. Boudreaux that one way or another, law enforcement will look at his phone. They can either get a warrant, which will take a long time, or Mr. Boudreaux can give consent for them to look at his phone in a report. At his phone. In her report, Detective Graves highlights that Mr. Boudreaux seemed concerned about how long he would be without his phone. She tells him consent will be faster than a search warrant. Mr. Boudreaux asked for clarification on what she would be looking at in his phone. Detective Graves explains there's a ton of information in a phone, but she only cares about a few specific things, namely copies of the texts that were sent and those things. Mr. Boudreaux asks if that means Detective Graves can go back in time on the phone. She explains she can set the date range in her search to a tiny period on the phone. She says she'll put it from 2 or 3 days before the initial event up until today. Detective Graves explains she'd be constrained to looking at just the information and nothing else, just this. Detective Graves likens the phone search to looking for an elephant in a house. If she's looking for an elephant in a house, she explains she can't go looking through drawers or other places that elephants wouldn't be. Mr. Boudreau confirms again that Detective Graves is only going to be looking at the text messages and the website she referenced earlier in the interrogation. It is with this understanding of the scope of the search that Mr. Boudreau gives Detective Graves permission to search his phone, and with that, his passcode. At the time, Mr. Boudreau was 20 years old. Mr. Boudreau has never been interrogated in police custody before. He demonstrates throughout the interrogation that he has little to no experience with the criminal system by expressing ignorance and confusion over how setting bond works, how pretrial detention works, and how charges are filed. Mr. Boudreau has never consulted an attorney in regards to his rights before. Law and argument. The Fourth Amendment to the United States Constitution protects all people against unreasonable searches and seizures. People versus Cherry. To be constitutionally valid, a consent to search must be given voluntarily and ambiguously. People versus O'Haran. A voluntary consent to search is a consent intelligently and freely given without any duress, coercion, or subtle promises or threats calculated to flaw and free and unconstrained nature of the decision. Voluntaries in the context of a search is a fact-sensitive question to be determined from the totality of the consequences. The prosecution must prove the voluntariness of the consent by clear and convincing evidence. The question of whether the consent was voluntary is answered by considering whether the consent was the product of an essentially free and unconstrained choice by its maker and not the result of circumstances which override the consenting party's will and critically impair his or her capacity for self-determination. A court deciding the issue of consent must determine whether there is objective evidence of overbearing, intrusive, coercive, or deceptive behavior by the police, such that the police conduct relative to the defendant's particular characteristics and circumstances was overbearing and critically impaired the defense's capacity for self-determination. So basically, what I'm reading to you here is what police have to follow when getting consent to search a phone. Any limitations placed on the consent, either express or implied, must be honored. Mr. Boudreau did not give voluntary consent for his phone to be searched. Whether a consent is voluntary depends upon the totality of the circumstances. U.S. versus Drayton. Courts should consider the consenter's age, education, intelligence, and state of mind, as well as the officer's demeanor and tone of consent. People in the interest of RA 937, P2D 738. Also, if import is whether the alleged consenter is in custody. Here, Mr. Boudreau was 20 years old at the time he is alleged to have consented in the search of his phone. His questions for Detective Graves regarding how a search of his phone would work belies his ignorance of exactly what he is consenting to. Now, this is the attorney stating why they should throw this out, because he didn't grasp what exactly was going on. Detective Graves' explanation that she'll be walking into a library and only selecting specified books off the shelves and not opening every drawer to find an elephant do not accurately portray to Mr. Boudreau how law enforcement is about to search his phone. Mr. Boudreau's questions around how bond is set and how cases proceed demonstrates his lack of understanding of the criminal system. This alleged consent took place around 10 p.m. after almost an hour and a half of interrogation. Mr. Boudreau has been handcuffed in an interrogation room under guard the entire time after explicitly being told he was in custody. Additionally, Detective Graves is clear, consent or not consent, she will be able to look at his phone. This is an inaccurate understanding about how warrants and consent functions. Given the totality of the circumstances, Mr. Boudreau did not give voluntary consent for his phone to be searched, nor did he voluntarily give his passcode as part of that consent. So the defense is saying because she told him one way or another, we are going to look at your phone, they're saying he did not give voluntary consent. Okay. Given the totality of the circumstances, Mr. Boudreau did not give voluntary consent for his phone to be searched, nor did he voluntarily give his passcode as part of that consent. To the extent the court finds Mr. Boudreau's consent was voluntary, the search conducted fell outside of the scope of his permission. Mr. Boudreau involuntarily consented to a search of his phone and gave his passcode after he understood the scope of the search to be limited to text messages and websites already discussed during the interrogation. Though Detective Graves' elephant metaphor, it is clear that Mr. Boudreau believed the search would and could be so closely limited that law enforcement would be looking at nothing else other than the specific text messages and websites already mentioned. All evidence obtained as a result of Mr. Boudreau's involuntary consent and the search conducted outside the scope of said consent is fruits of the poisonous tree and must be suppressed. Excuse me. The fruits of the poisonous tree doctrine provides the evidence obtained by the police through unlawful means, such as an illegal entry, is inadmissible and must be suppressed. People versus Prescott. Wherefore, Mr. Boudreau moves this court to suppress all searches on his phone conducted without his consent and beyond the scope of any consent that may have been voluntarily given, as well as any searches conducted with the use of his passcode involuntarily given with a particular scope in mind. So, once again, the defense is saying Donovan only agreed for her to look at the text messages and the websites that they talked about in his interrogation. But when we looked at the search warrant they got on the phone last night, it went more in depth. They were able to look at more information that was just given in the interrogation because of the search warrant. Okay. I just have to look at something real quick and then we'll continue. Okay, I can show this next document. So now we're doing motion to suppress statement obtained illegally from Mr. Boudreau. This first part is pretty much the same as what I just read above. Okay. He's handcuffed, marched into the interrogation room, interrogated by Detective Graves for 2 hours. At all points, he's handcuffed. He remains in the interrogation room. At no point is he allowed to speak with an attorney, a friend, his father, his mother, or anyone other than Detective Graves. It appears officers remains outside the room through the whole interrogation. Once he's seated, officers who brought him have left. Detective Graves reads him his Miranda rights, has him sign the waiver of rights, and then proceeds to ask him questions for approximately 2 hours. Talks about the bond again. And then we get into the different law and argument of why his statement should be thrown out. Mr. Boudreau was subject to custodial interrogation. Mr. Boudreau was in custody starting when he was handcuffed at the police station. An individual is in custody when he is deprived of his freedom of action in any significant way. Miranda versus Arizona. Whether an individual is in custody is determined by making 2 inquiries. First, what were the circumstances surrounding the interrogation? And second, given those circumstances, would a reasonable person have felt that he or she was not at liberty to terminate the interrogation and leave? Thompson versus Kehane. Courts utilize a totality of the circumstances test in conducting these inquiries. People versus Matheny. Factors a court should evaluate include the time, place, and purpose of the encounter, the person present during the encounter, the words spoken by the officer to the defendant, the officer's tone of voice and general demeanor, the length and mood of the interrogation, whether any limitation of movement or other form of restraint was placed on the defendant during the interrogation, the officer's response to any questions asked by the defendant, whether direction was given to the defendant during the interrogation, and the defendant's verbal or nonverbal responses to such direction. As acknowledged by Detective Graves, Mr. Boudreau was obviously in custody when handcuffed and marched into an interrogation room in the Montrose Police Department. He was interrogated when Detective Graves asked him questions. Interrogation is defined as express questioning or its functional equivalent. Rhode Island versus Inez. This includes any words or actions on the part of the police other than those normally attendant to arrest and custody that the police should know are reasonably likely to elicit an incriminating response. In making a custodial interrogation determination, a court must consider the totality of the circumstances under which the interrogation was conducted. People versus Barraza. While in custody, Detective Graves asked Mr. Boudreau questions and made statements or actions that were reasonably likely to elicit an incriminating response. Under the totality of the circumstances, Mr. Boudreau was subjected to custodial interrogation on scene. Mr. Boudreau's statement must be suppressed because they were involuntary. All statements made by Mr. Bourgeois were involuntary, and admission of the statements would violate his due process rights as guaranteed by the 5th and 14th Amendment to the U.S. Constitution and Article 2, Section 6 and 25 of the Colorado Constitution. A statement that is involuntary is not admissible for any purpose. People versus Clinic. An involuntary statement is one where there is evidence of some form of coercive governmental action that plays a significant role in inducing the statement. Coercive police conduct includes not only physical abuse or threats directed against a person, but also subtle forms of psychological coercion. A statement's voluntariness is evaluated on the basis of the totality of the circumstances under which it's given. Relevant circumstances include the occurrences and events surrounding the confession and the mental condition of the person making the statement. Deliberate exploitation of a person's weakness by physical intimidation can constitute a form of government coercion that renders a statement involuntary. Other relevant factors important to the evaluation of voluntariness are whether the defendant was in custody or is free to leave and was aware of his situation, whether Miranda warnings were given prior to any interrogation, and whether the defendant understood and waived his Miranda rights, whether the defendant had the opportunity to confer with counsel or anyone else prior to the interrogation, whether the challenged statement was made during the course of an interrogation or instead was volunteered, whether any overt or implied threat or promise was directed to the defendant, the method and style employed by the interrogator in questioning the defendant and the length and place of the interrogation, and the defendant's mental and physical condition immediately prior to and during the interrogation, as well as education background, employment status, and prior experience with law enforcement and the criminal justice system. People versus Efland. Once a defendant has challenged a statement as involuntary, the prosecution must establish by a preponderance of the evidence that the defendant's statements were voluntarily given. People versus Vigil. People versus Eflin. It must also establish that the statement resulted from a free and unrestrained choice by the maker. People versus Medina. Involuntary statements are inadmissible at trial regardless of the defendant's custodial situation and whether or not the defendant made an inculpatory statement. People versus Medina. In People versus Medina, the Colorado Supreme Court upheld the suppression of a defendant's statement. The court in Medina closely considered Mr. Medina's physical and mental state. The court found that the deliberate exploitation of a person's weaknesses by psychological intimidation can render the statements involuntary. Medina was suffering from emotional and psychological distress, which the police exploited, and ultimately that the threat played a significant role in inducing Medina's confession. So are they trying to say that Donovan at this time had a psychological issue or emotional issue which makes any statement he said involuntary? I think so. Applying the factors in Eflin, none of Mr. Boudreau's statements made were voluntary. So that's what they're stating. Mr. Boudreau was not free to leave, and his handcuffs, the closed door, and an armed officer present made that clear. Mr. Boudreau was advised of his rights under Miranda. However, he has never been interrogated by law enforcement before, nor has he ever consulted with an attorney regarding his rights before. As such, whether such rights were understood is dubious. So because he's never talked to the police before and never been in this situation and contacted a lawyer, he didn't know what he was doing, and therefore all of his statements are involuntary. Well, let me tell you, if you follow cases such as Athena Strand, the Canadian serial killer, and the Idaho 4, you know more about how the law works than just being blindsided because it's never happened to you before. That's my thoughts. I've never been arrested. I've never been talked in front of anybody. But if I were to be arrested, I would know what my rights are and what to do by things that I have seen in this community and by watching trials. So I think this is just fluff, an attempt to get something thrown out. As such, whether such rights were understood is dubious. Mr. Boudreau was unable to consult with counsel nor with anyone during the 2-hour period of time. Ruckus, please tell me, is this uncommon when you're being interrogated by a police officer? Are you normally allowed to have contact with your mother, father, whatever? Unless you ask for an attorney, they don't let you have contact with anybody during an interrogation. Mr. Boudreau was unable to consult with counsel nor with anyone during the 2-hour period of time. Mr. Boudreau's statement to law enforcement are made during a custodial interrogation, not simply volunteered. Detective Graves overly tells Mr. Boudreau she'll tell the judge to release him pre-trial if he answers her questions, and that she may have to tell the judge he's a dangerous serial killer if he doesn't speak with her. The interrogation takes place over 2 hours, which has been repeated like 3 times in this paragraph. Mr. Boudreau has no prior experience with the criminal justice system that gave him insights into his rights or how interrogations work. Given the totality of the circumstances, his statements are involuntary and should be suppressed. Him being Mirandized said that he could have an attorney present. That's part of the Mirandized. So that right there, ding ding, in your head, any normal person, whether you've gone through this before or not, can decide whether to talk to police with or without a lawyer. Ignorance, just not a good thing in my book. Therefore, Mr. Boudreau moves this court to suppress all statements made to law enforcement, starting when he is handcuffed and marched into the interrogation room as they were involuntarily made. Under the fruits of the poisonous tree doctrine, Mr. Boudreau requests suppression of all evidence obtained as a result of involuntary made statements. Maybe. Exactly. This guy is sneaky. He's trying to play it up for all it was worth. Yeah. You got that right. Yes. And this isn't a child, this is an adult. So, all right. Preliminary endorsement. Nature of defense. Mr. Boudreau asserts that the prosecution will not be able to prove his guilt beyond a reasonable doubt. Mr. Boudreau invokes the alternative suspect defense. Reports of statements of experts. The defense may have expert testimony in this case and will provide the necessary information if and when an expert is retained. Rebuttal witnesses. Mr. Boudreau requests reciprocal discovery of rebuttal witnesses as specified in Colorado R. Crim P. Rule 16, at least 35 days prior to trial. Rights to amendment endorsement. Pursuant to Mr. Boudreau's right under the Colorado Rules of Criminal Procedure, as well as his constitutional rights to effective assistance of counsel and right to confrontation provided by Article 2, Section 16 of the Colorado Constitution and the 6th and 14th Amendments of the United States Constitution, Mr. Boudreau reserves the right to amend this endorsement up until the conclusion of trial. Witnesses who Mr. Boudreau may call at trial in support of the defense indicated in Part 1 above are Melissa Wilson, investigator, Sean Wells, investigator, Jessica Martinez, investigator, Molly Yorchik, investigator, public defender, advisory witnesses, any and all witnesses endorsed by the prosecution, any and all persons listed in discovery, any and all witnesses needed to impeach or rebut testimony, including officers, any such witnesses whose names and materiality first become known to the defense at the time of the trial. Exhibits. The exhibits that Mr. Boudreau may offer at trial in support of the defense indicated in Part 1 are any and all photographs, CDs, DVDs, or videos in discovery. Any and all items listed in discovery that are pertinent to the defense listed in Part 1 above. Any and all items endorsed in the prosecution. Any exhibits needed to impeach or rebut testimony. Any exhibits as further endorsed or discovered by defense counsel. Any and all exhibits included in or discovered as a result of discovery or additional investigation. Mr. Boudreau preserves the right to not provide notice of exhibits pursuant to People versus Kilgore. Objection to exhibits. Mr. Boudreau objects to all the exhibits under the principles of the Colorado and federal Constitution, the Colorado Rules of Evidence, and all relevant Colorado statutes. Mr. Boudreau maintains his right to object to all objectionable evidence up until the prosecution offers the evidence for admissibility during the trial in this matter. Okay. This calls for a cigarette. Yeah. We got to get through this because it educates us on what is happening here. Okay? And we're actually doing a good job. These aren't as long as that first document. Okay. Motion to suppress fruits of illegal searches of Mr. Boudreau's electronic devices because they are unconstitutionally overbroad. Once again, he's handcuffed, marched into an interrogation room, had involuntarily given consent to search very particular portions of his phone, along with his passcode for said purposes. Officer Grubbs requests a search warrant for Mr. Boudreau's green iPhone. The warrant requests a search warrant too. These are all the things that we discussed last night. This is why they were able to go beyond emails and texts, because in their search warrant, it listed everything for a date, a time period, only for a time period. This warrant lacks the specification and particularity required for a valid search warrant. The Fourth Amendment of the United States Constitution and Article 2(7) of the Colorado Constitution prohibit the issuance of a search warrant that lacks sufficient probable cause. The Fourth Amendment prohibits... Am I still with all of you? Let me know in the chat if I am still with all of you, because the power is flickering. Okay. Thank you, Andrea, and rescue all the dogs. Crazy stuff going around here. This constitutional bulwark safeguards the privacy and security of individuals against arbitrary invasions by government officials. P versus Koch. The Fourth Amendment of the United States Constitution provides that no search warrant shall issue except one, particularly describing the place to be searched and the persons or things to be seized. 3 requirements must be satisfied in order for a warrant to issue under the warrant clause of the Fourth Amendment. Probable cause, supported by oath or affirmation, and particularity describing the place to be searched and the person or things to be seized. Well, wouldn't a search warrant for a phone listing all those different things definitely be warranted in this case? Affidavits must describe the items sought with particularity. People versus Hardy. An affidavit cannot simply state conclusory statements. The affidavit must demonstrate a reason to believe that evidence of criminal activity exists in the place to be searched. I mean, come on. Okay. We know that evidence is there. The text messages came off his phone. Okay. I'm going to skip the rest of that because it's just nonsense. This applies. Let's get to their points. A warrant is overly broad if it does not contain sufficiently particularized language that creates a nexus between the suspected crime and the things to be seized. United States versus Campos. Additionally, mere suspicion does not give rise to probable cause. People versus Alamino. When it is clear that the facts surrounding a search indicate that the search was exploratory in nature, the warrant shall be characterized as authorizing an impermissible general search. They knew the text messages were on there. He sent them. Cell phones and computers require even further specificity with particularity and limits speculation because they hold a vast array of a person's private information. Cell phones are entitled to special protections because for any Americans, they hold the privacies of life. The Colorado Supreme Court has held that a search of a cell phone simply for general indicia of ownership would violate the Fourth Amendment particularity requirements. In Koch, the warrant allowed for the search of the following: data, which tends to show possession, domination, dominion, and control over said equipment, including but not limited to system ownership information, phone number, pictures, or documents bearing the owner's name or information. Any electronic data that would be illegal to possess, contraband, or fruits or proceeds of a crime, or data intended to be used in the commission of a crime. All telephone contact lists, phone books, and telephone logs. Any text messages and multimedia messaging services stored, sent, received, or deleted. Any photographs or images stored, sent, received, or deleted. Any videos stored, sent, received, or deleted. Any electronic data packets stored, sent, received, or deleted. The Koch count found that this warrant was illegally broad and without the necessary particularity, in part because it allowed officers to search all contact lists and any data that showed ownership or possession. The principal means of effectuating the particularity requirement is to suppress all evidence seized pursuant to an overbroad general warrant. Because the warrant in Koch failed to specify as required, the Koch court affirmed the suppression of the entirety of the contents of Koch's cell phone. The courts have held that similar protections are necessary for personal computers. Warrants for computer searches must affirmatively limit a search to evidence of specific crimes or specific types of material or data. United States versus Otero. The state argued a warrant authorizing search of cell phone for specified texts and indicia of ownership authorized a broad search on the ground that any piece of data on the phone, including any text message, would have the possibility of revealing ownership. The court rejected that argument because it would authorize a general search of the entire contents of the phone and transform the warrant into a general warrant that fails to comply with the Fourth Amendment particularity requirements. United States versus Bridge. A warrant invalid where list of items was detailed but overbroad. It was a comprehensive laundry list of sundry goods and inventory that one would readily expect to discover in any business, and the not limited to modifier authorized of seizure of anything at all. Okay. Finding a warrant that lists items and authorized search for all other evidence of criminal activity invalid. The modern development of the personal computer and its ability to store and intermingle a huge array of one's personal papers in a single space increases law enforcement's ability to conduct a wide-ranging search into a person's private affairs, and accordingly makes the particularity requirement that much more important. Using using the same logic, a computer and cell phone should be treated in the same regard. The Fourth Amendment does not allow officials executing a warrant for seizure of particular data on a computer to seize and infinitely retain every file on the device for use in future criminal investigations. While an officer's training and experience may be considered in determining probable cause, such training and experiences cannot substitution for an evidentiary nexus prior to the search between the place to be searched and any criminal activity. The warrants in this case allowed for the same sort of general exploratory search disallowed in Koch and Hiera. As in Hiera and Koch, this court should find that these generalized requests with no limitation violate the requirements of particularity and specified requests based on probable cause that information pertaining to the crime will be found in a specific location. Thus, the court should find that each of these warrants is overbroad in its scope and suppress all the contents. People's preliminary endorsement of a witness exhibit. Now, as you can see, there's a lot here that has been redacted. So I'm not even going to try to read it. This is basically just the witness list. Any and all witnesses needed to impeach or rebut testimony. Any all witnesses needed to authenticate exhibits. Any witnesses endorsed, subpoenaed, or called by defendant. Any witnesses necessary to lay evidentiary foundations or prove chain of custody. Any witnesses may be further identified by the people. The people endorse the following exhibits. Any and all photographs, CDs, DVDs, videos, or other recordings, if any, taken in this case. Any and all items listed on property evidence reports. Any and all items listed on evidence.com. Criminal histories and or criminal records of all witnesses in this case. Any and all protective orders. Any exhibits endorsed by the defendant. Any exhibits needed to impeach or rebut testimony. Any exhibits as may be further endorsed and or identified by people. Custodian of business records, including dispatch personnel. Any and all exhibits realized as a result of discovery. This is just a transcript form. Okay, so this is criminal jury trial order, December 12, 2023. The defendant has entered a plea of not guilty on December 11, 2023, and this matter is set for jury trial to a jury of 12 plus one alternate for 8 days beginning June 3rd, 2024. Parties to appear at 8:30 a.m. for preliminary matters. All motions and notices in limine and motions directed lowered expert testimony are to be filed within 60 days. So this is all talking about what's going to happen in the trial. All right. I'm just making sure because I believe this was all pretty much read. Okay. No, it was not. This is the part that everybody has been waiting to hear. Besides the plea agreement. This document shows information on it that I think should have been further redacted. Without further redaction, it will clearly provide information to anybody in the Colorado community that could identify the victims. Therefore, just like last night, I will not be showing this one online. But I am going to read it. Order following October 11, 2023, preliminary hearing finding probable cause shown as to the charges and ordering bind over for arraignment. Filed October 27, 2023 at 4:24. On October 11, 2023, the court held a felony preliminary hearing in the above caption cause as to count 1 through 48. Mr. Boudreau appeared in person in custody with counsel, Ms. Lyon. Ms. Thompson appeared for the prosecution. The prosecution called redacted, one of the named victims and father of redacted, and Detective Samantha Graves from the Montrose Police Department. Both witnesses testified under oath. During Redacted's direct examination, the prosecution sought to admit 8 exhibits. People's Exhibits 1, 2, 3, 4, 5, and 6 were admitted for purposes of preliminary hearing over defense's objection. For purposes of the hearing, the defense did not object to admission of People's Exhibit 7 and 8. People's Exhibit 1 through 8 are all single-page printouts of text message screenshots or photographs. During Detective Graves' direct examination, the prosecution sought to admit 5 additional exhibits. People's Exhibits 10, 12, and 13 were admitted for purposes of preliminary hearing over defense's objection. For purposes of the hearing, the defense did not object to admission of People's Exhibit 9 and 11. People's Exhibit 9 is a black and silver flash drive containing videos and images, and the parties stipulated prior to testimony at preliminary hearing that the material is actually exploitative and depicts a child for purposes of preliminary hearing only, except as to video 0426, charged as count 6, and video 0435, count 12, for which defendant contested designation of actually exploitative material. People's Exhibit 10 is a black flash drive containing a video file. Defendant's recorded interview with Detective Graves. Donovan Boudreau interview, MP4, 2 hours, 8 minutes, 29 seconds in length. The parties requested that the court review this video in its entirety in chambers prior to issuing a ruling on probable cause. People's Exhibit 11 is an 8-page document, printed screenshots of a Facebook Messenger message attributed to the defendant. People's Exhibit 12 is a 10-page document, a celebrate extraction report related to images. People's Exhibit 13 is a 5-page document, a celebrate extraction report related to videos. Due to the content of People's Exhibit 9, which contains actually exploitative material involving persons under the age of 18, as stipulated by the parties, this exhibit will be maintained by the court as a sealed exhibit in the record in this case. Following direct examination, cross-examination, and redirect examination by the parties of the above-named witnesses, the prosecution rested. Defendant did not call witnesses. The parties were instructed to file written closing arguments by October 18, 2023, and the court set this matter for hearing on October 25, 2023 at 4 p.m., at which time the court would issue an oral ruling if a written order did not issue beforehand. Counsel for defendant filed a short written closing statement on October 18, 2023. The prosecution did not file a written closing argument. On October 25, 2023, the court issued an order vacating the hearing and notifying the parties that a written order would issue on October 27, 2023. The court now issues this order to memorialize in writing the court's findings and order regarding probable cause following the hearing and review of the prosecution's exhibits as outlined above. Applicable law preliminary hearing. To establish probable cause for purpose of preliminary hearing, the prosecution must present evidence sufficient to induce a person of ordinary prudence and caution to entertain a reasonable belief that the defendant may have committed the crime. Probable cause must be established as to each element of the crime. A judge at preliminary hearing must view evidence in light most favorable to the prosecution. A judge must also draw all reasonable inference in favor of the prosecution. If there is conflicting testimony, the judge must also draw conflicting inferences in favor of the prosecution. The prosecution may not rely solely upon hearsay evidence to establish probable cause when a perceiving witness is available to testify. However, hearsay evidence may form the bulk of the evidence in the preliminary hearing. Count 1, elements of stalking. The elements of stalking pursuant to, and it gives the code, are that the defendant in the state of Colorado at or about the date and place charged knowingly made a credible threat to another person, either directly or indirectly through a third person, and in connection with the threat, repeatedly made any form of communication with that person, a member of that person's immediate family, or someone with whom the person was having previously had a continuing relationship, regardless of whether a conversation ensued. Knowingly is defined as follows. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is such nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. A credible threat is defined as a threat, physical action, or repeated conduct that would cause a reasonable person to be in fear for the person's safety or the safety of an immediate family or of someone with whom the person has or has had a continuing relationship. The threat need not be expressed if the totality of the conduct would cause a reasonable person such fear. Immediate family includes the person's spouse and the person's parent, grandparent, sibling, or child. Conduct in connection with a credible threat means acts which further advance, promote, or have a continuity of purpose and may occur before, during, or after the credible threat. Repeated or repeatedly means on more than one occasion. Conduct in connection with a credible threat means acts which further advance, promote, or have continuity of purpose and may occur before, during, or after the credible threat. The prosecution must prove in a true heights case that the defendant has some subjective understanding of his statements' threatening nature, but the First Amendment requires no more demanding a show than reckless. Detective Graves identified defendant Mr. Boudreau in open court during preliminary hearing. Detective Graves confirmed that she interviewed Mr. Boudreau. The date stamp on People's Exhibit 10 shows this occurred on March 20th, 2023. Detective Graves also testified that Mr. Boudreau initially denied sending messages to Redacted. However, after Detective Graves confronted Mr. Boudreau that she obtained evidence that tied the IP address on Mr. Boudreau's phone to all three VoIP numbers that contacted Redacted, Mr. Boudreau admitted to being the person who sent the messages sent to Redacted, shown in People's Exhibits 1, 2, 3, 4, 5, and 6. To JR, Mr. Boudreau's admission is shown in People's Exhibit 10, beginning at 2957 and 5344 and 13519. Detective Graves testified that after Mr. Boudreau confirmed that he was the person that sent the messages referenced above to Redacted, and that he did so because he wanted attention, he wanted to be close to Redacted and Redacted, he essentially envied Redacted and his ability to swim, and that Redacted was intended recipient of these messages. Mr. Boudreau told Detective Graves as much as shown in People's Exhibit 10, 38 minutes. People's Exhibit 4 and 5 include statements sent to Redacted in reference to Redacted that include, with that blue-looking Speedo he wears every day, he's just asking for it. Kissing face emoji. Redacted literally asking for it. Don't you get that? Redacted testified the Redacted wore a blue swimsuit when swimming. People's Exhibit 6, the last in the string of messages sent to Redacted on March 14th, 2023 states in part, "I'm glad because redacted is truly amazing. So sexy. I'm literally obsessed with his physique. I swear one day I'll get a taste of him. Not as if I can already taste him. He's the redacted and I'll be the redacted. Remember that." Heart emoji. Redacted testified that he couldn't bring himself to look up who redacted and redacted were that night, but that the next day he did, learning that redacted was a man in Texas that had struck redacted with his FedEx truck, and when she said she was going to tell her father that he murdered her. Redacted testified that he was very worried about the safety of his son. For purposes of probable cause, the messages repeatedly referencing redacted, indicating surveillance of him over a period of time, and including the statements regarding redacted and redacted, are sufficient related to credible threat, a threat, and repeated conduct that would cause a reasonable person, redacted, to fear for his safety, and more specifically, his son. People's Exhibits 1, 2, 3, 4, 5, and 6 show multiple messages sent to redacted by Mr. Boudreau, and redacted testified that he received those messages on March 14th, 2023. Redacted further testified that he got a phone call on March 15th, 2023 from somebody saying they were a detective from the Montrose County Sheriff's Office, but his phone identified the number as spam. And the caller left a voicemail. The voicemail indicated that the caller was from Sheriff's Office and wanted to speak with redacted. Redacted then got 3 more calls from the same number and a text message attempting further communication with redacted. Redacted called the Montrose County Sheriff's Office dispatch on March 16th and was informed that no detective with that name left in the voicemail was employed with the department. And the sheriff's office designates detectives as investigators and not detectives. Redacted testified that this confirmed his suspicions that the person/number contacting him on March 15, 2023 was not someone from law enforcement. We're going to stop here because you cannot, as an individual, as a parent, just assume that somebody contacting you and leaving you a message is law enforcement. This case study proves that. If you have any doubts whatsoever, contact your sheriff's office, police department, like this individual, this father did, and verify the police officer that is leaving you the message. Don't just assume it's legit. Detective Graves also testified that Mr. Boudreau explained that he was a lifeguard at said pool. In this employment, he had observed redacted during redacted swimming, asked a coworker for redacted's name, and had gotten redacted's father's name from this coworker. Mr. Boudreau also told Detective Graves that the day before texting redacted, which the court takes to mean March 13th, 2023, he conducted an internet search and obtained names and personal phone numbers for redacted. This conversation is also shown in People's Exhibit 10. Thus, viewing evidence in the light most favorable to the prosecution, the above is sufficient to demonstrate that Mr. Boudreaux in Montrose County, state of Colorado, on March 14th and March 15th, 2023, with intent, knowingly, as his conscious objective was to contact redacted and communicate a threat of harm regarding redacted through referencing redacted and redacted, as well as other messages in People's Exhibit 1 through 6, stating redacted was asking for it, and I swear one day I'll get a taste of him, and did so make a credible threat and connection with this threat, repeatedly contacted redacted by text message and phone calls. The court also notes the additional testimony and evidence outlined below as to count 2 and 3. Defendants' repeated telephone contacts and in-person contact with redacted on March 19th. So the reason I read that one is because I wanted you to hear what was on the drives. There were videos. There were pictures that they found. But as far as I can tell and see, they did not directly relate to the charges for this defendant. So what did they show? What did they show? That's my question. And are police investigating further? Now it goes on to talk about him delivering the pizza and all that. I'm not going to read through that again. It basically just states everything that was read to you last night, showing that there's reason for these charges to stick. It does go through counts 4 through 31. That says the elements of actual exploitation of a child pursuant to, gives the code, or I can't think of the word, are that the defendant is in the state of Colorado and or about the date and place charge knowingly for any purpose, accessed with intent to view, viewed, possessed, or controlled any actually explicitative material. As defined above, actually explicitation of a child is a Class D felony if the item assessed with intent to view, viewed, possessed, or controlled is a video recording or broadcast of moving visual images or motion pictures. Actually exploitative material is defined as any photograph, motion picture, video, recording, or broadcast of moving visual images, live stream, print, negative, slide, or other mechanically, electronically, chemically, or digitally reproduced visual material that depicts a child engaged in, participating in, observing, or being used for explicit sexual conduct. Child is defined as any person under the age of 18 years. Detective Graves testified regarding People's Exhibit 13, a Celebrate report listing videos, MP4 files extracted from Mr. Boudreau's cell phone, which was seized at the time of his arrest. Mr. Boudreau and Detective Graves talk at length during his March 20th, 23 interview about his cell phone, the process of forensic extraction, and law enforcement's intention to seek a search warrant to search the device. See People's Exhibit 10. Mr. Boudreau also confirmed his cell phone make and model, phone number, and passcode to Detective Graves during the March 20th, 23 interview. Exhibit 9, which are images and video files, reflect the People's Exhibits 12 and 13, and that all image and videos reflected therein were stored on Mr. Boudreau's cell phone. His cell phone was sent to the Mesa County Sheriff's Office, which does forensic digital downloads for the Montrose County Police Department. Detective Graves testified that these files were uploaded between March 11th and March 19th, 2023, as shown in People Exhibit 13. There is a date of access for each file, and each file has different metadata. The court's review of People's Exhibit 13 shows these files are MP4 files, MOV files, and 3 GP files. Each file has a different created timestamp and different access timestamp, and there are 29 video files listed in the report. Detective Graves testified that she, the forensic analyst of Mr. Boudreau's phone, revealed several pornographic videos and images involving underage children. The court's review of Exhibits 9 confirms that the files labeled as followed in the amended complaint and information, and it gives all these file numbers. Thus, viewing the evidence in the light most favorable to the prosecution, the court finds it sufficiently shown that Mr. Boudreau in the state of Colorado on and around March 11, 2023 through March 20th, 23, knowingly for any purpose assessed with intent to view, viewed, possessed, or controlled the actually exploitative material contained in videos, and it lists the numbers. The court incorporates by reference the element of actual exploitation of a child referenced above on page 8 of this order. Defendant is charged with a violation of the statutory subsection as to count 6 through 12, or 6 and 12. The court incorporates by reference the evidence and testimony from preliminary hearing referenced above as to counts 5, 7, 8, 9, 10, 11, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, and 31. Now we're talking about counts 32, 34, 36, 37, 38, 39, 40, 41, 43, 44, 46, 47, and 48. Detective Graves testified regarding People's Exhibit 12. This exhibit is a Celebrate report related to images that were extracted from Mr. Boudreau's cell phone. The report listed image files in JPEG, HEIC, and THM format, similar to People's Exhibit 13. Each listed image file in People's Exhibit 12 shows created and assessed dates and times, and these are different for each file listed. The dates of creation assessed range from March 10th through March 19th. At preliminary hearing, Detective Graves testified that though because of the metadata, wait, I skipped a line. Detective Graves testified that though some of these images appear similar, it was her opinion they are different digitally because of the metadata, see e.g. image 12 as designated in the Celebrate report, and image 20, which it was argued are similar images, but both reflect different file size in bytes and source file names. The court review of People's Exhibit 9 confirms that the file labeled as follows in the amended complaint and information: image 8, top left corner and bottom left corner; 9, top left corner, top right corner, bottom left corner, and bottom right corner; 12, top left corner, top right corner, bottom right corner; 20, 22, and image 23 are digital photographs. Thus, viewing the evidence in the light most favorable to the prosecution, the court finds it sufficiently shown that Mr. Boudreau, in the state of Colorado, on or about March 11th, 2023, through March 20th, 2023, knowingly for any purpose assessed with intent to view, viewed, possessed, or controlled the actually explicit material designated as images 8, top left corner and bottom left corner; 9, top left corner. I'm not going to read the corners again. 12, 20, 22, and image 23, which are digital photographs. The court has considered the evidence and testimony presented at the hearing orders. For reasons stated above, the court finds probable cause was established to each element of count 1, stalking, pursuant to code as class 5 felony, and to believe that the offense has been committed and has been committed by defendant Mr. Boudreau. For reasons stated above, the court finds probable cause was established as to each element of count 2, stalking. And it just goes down further to say they find probable cause for each and every single count. Upon review of People's Exhibit 9, video 0426 and 0435, and in light of the evidence and testimony presented at preliminary hearing, the court finds probable cause was established as to each element of counts 6 and 12, pursuant to statute, as a class 4 felony, and to believe that the offense has been committed and has been committed by defendant Mr. Boudreau. So you get it. You get they found him they find probable cause on behalf of the prosecution, the evidence that they provided. So what happened? What was the result of all this? Well, it was supposed to go to jury trial the beginning of June. However, the defendant, Donovan Boudreau, made a plea agreement. So what is in that plea agreement? I know that I have the right to remain silent, that I do not have to submit this petition. If my plea is accepted, then anything I may state in this petition may be used against me as the defendant in this case. I state that all of my statements in this petition are true. Excuse me for... I have done a lot of reading today. Defendant is to confirm that he or she has read each section by placing his or her initials on the line to the left of each section. I waive my right to a preliminary hearing in this case. N.A. My name is Donovan Boudreau. My date of birth, my age is 22. I am able to read, speak, write, and understand English. I am a citizen of the United States. I have completed school through the 12th grade plus 0 years of college. I'm not under the influence of any medication, alcohol, or other drug which would prevent me from understanding this petition. I'm not now mentally ill, nor am I suffering from any physical, mental, or emotional disability which would prevent me from understanding this petition. I understand that I have the right to have an attorney to help me in this case, and that if I apply and qualify for court-appointed counsel, then the court will appoint an attorney to help me and to represent me in this case without cost, except for the fee to apply for a court-appointed attorney. I am proceeding without an attorney, and I voluntarily give up my right to have an attorney. He did not check that one. He checked, my attorney is Virginia Lyon, and I'm satisfied with his or her help to me in this case. My attorney has explained to me when his or her representation of me will end. I have fully discussed with my lawyer everything I know about this case, including all defenses available to me. I know what evidence the state can present against me if this case goes to trial. I am in jail and have the right to be released from jail by posting a bond of $10,000 cash only. I realize that unless I received a deferred sentence, my plea of guilty will result in a conviction. And if I am on bond, I must file with the court written consent for all sureties on my bond, indicating their agreement for me to be released until my sentencing hearing. I understand that any plea I enter in this case must be voluntary, meaning of my own desire, made of my free will, without any undue influence, force, or threat made by anyone against me, and without my permission, or without any promises to me, except those stated in my plea agreement. I know I do not have to follow my attorney's advice, and I do not have to plead guilty. The decision to plead guilty is my decision, and it has been made freely and voluntarily by me. I understand that I have the following rights, and that by pleading guilty, I am giving up all of these rights. The right to be presumed innocent, which means I am not considered to be guilty just because I have been charged with a crime. The right to have a trial to determine if I am guilty or not guilty. The right to public and speedy trial, that is the right to have a trial set within 6 months after a plea of not guilty is entered. The right to have a trial by jury of 12 people, at my request, a trial by judge without a jury, if the district attorney consents. I understand that my decision by the jury must be unanimous. All jurors must agree the same decision. The right to require the district attorney to prove beyond a reasonable doubt all of the elements of each charge against me. The right to be in open court, to see and hear the witnesses called against me, and the right to question them about their testimony. The right to remain silent at trial, that is my right to choose not to testify without such decision being held against me, or the right to testify, that is to tell under oath that I know about what happened, to the jury or the judge. I understand that it is my own personal right to decide whether or not to testify. The rights to present my defense to a jury or a judge, and my rights to be found guilty of my less serious charge. I state that I have told my attorney all the facts known to me about the charges against me. We have talked about the charges and about any less serious offenses which I might be included in the charges against me. We have talked about all reasonable defenses I may have to any of these charges. The right to call witnesses to testify for me at my trial, and to get subpoenas to require them to be present at the trial if necessary. The right to file a motion asking the court to prevent the district attorney from using any evidence against me, my statements, property, or other evidence improperly taken from me by the police. The right to appeal a higher court all pretrial rulings and my convictions if I were to have a trial was found guilty at trial. I want to plead guilty to the following offense, the elements of which have been fully explained to me. I understand all the elements and the possible penalties for each offense listed. Count number 2, stalking, class F5, 8 years. Count 5, actually exploitation of a child, class F4, 12 years. And then there's mandatory parole on each one. Let me back up here on the stalking. It's 8 years, mandatory parole 2 years, possible fine $1,000 to $100,000. And as you can see here, sex offender sentencing provisions apply. So 12 years, mandatory parole 3 years. I understand that if at any time after I plead guilty, I am or become eligible for a sentence to the Department of Corrections, DOC, then any sentence I receive to DOC will include a mandatory term of parole as listed in 14 above. I further understand that CRS 1722.5, 403, 8, and 9 provide that if after being sentenced to DOC, I am paroled on any offense committed on or after July 1st, 1993, and I then violate my parole, I can be returned to the custody of DOC for any period up to the length of time remaining on my mandatory parole. I state that no agreement as to the sentence I am to receive, nor any other promise of condition listed in my plea agreement with the District Attorney's Office, which agreement is tendered to the court with this position to plead guilty, has caused me to decide to plead guilty to a crime which I did not commit, unless I'm entering a no contest plea or Alford plea as stated in paragraph 25 below. Except for any sentence agreement promised to me in my plea agreement, I understand that the judge can sentence me to any sentence within the penalty range for the offenses to which I am pleading guilty, as set out in paragraph 15 above. I understand that any statements made to me by my attorney or by any other person as to how I might be sentenced are not binding on the judge who sentences me. I know that if I am pleading guilty to more than one offense, the court can order separate sentences and/or fines for each offense and may require them to be served consecutively, one after the other, or concurrently at the same time. I know I will have to pay any restitution as part of my sentence. I know that if I'm pleading guilty to a X offense, I may be sentenced by the court to the Department of Corrections for an indeterminate term having a minimum of 1 day and a maximum of the balance of my natural life. I have attached to this petition attachment B, which contains a list of my rights and consequences to me of plea of guilty on the X offense committed on or after November 1st, 1998, including provisions relating to parole and probation. I have reviewed and understand the lifetime supervision X offender statute. See the lifetime supervision of X offender statute CRS 18 1-3 for parole or for probation. I know that if I receive probation on a felony offense, I can serve up to 90 days in jail without work release as a condition of probation. Or I can serve up to 2 years in jail with work release for each felony charge. I know that if I receive probation on a misdemeanor offense, I can serve up to 60 days in jail without work release as a condition of probation, or it can be ordered to serve a work release sentence for as long as the maximum sentence possible for each misdemeanor. I admit that there is factual basis for my plea of guilty on each charge to which I am pleading guilty, and that if a jury believed beyond a reasonable doubt the evidence which the district attorney is able to present at trial, then I would be found guilty on each charge to which I am pleading guilty. I give up any right to require the district attorney to prove a factual basis of the charge or charges to which I am pleading guilty. Voluntary plea agreement or voluntary plea. I am entering my plea of guilty intelligently, knowingly, and voluntarily, and state to the court that I have made the decision to plead guilty of my own free will. No one has used any undue influence, threats, or promises of leniency or special considerations to get me to plead guilty against my free will. I believe a plea of guilty is the best way for me to handle my case. I am entering a plea of guilty to the charges listed in paragraph 14 because I am guilty. I state that I understand all the information stated in this position. I realize that the court is relying on my statements in this petition to plead guilty and in my plea agreement as true statements of my understanding of the matters set out in each of these documents. If I attempt at any later time to claim that my plea was not voluntary, or that any representations or statements contained herein are not true, it will be only because new information has been discovered that was unavailable to me, so that I could not know the information at the time I entered my plea. Therefore, I state that I have carefully and completed review of all statements and representation in this petition, and the same are true to the best of my knowledge and belief. I agree that I shall assure that the court always has my current mailing address. Any complaint to revoke probation or deferral on any notice of continuance will be mailed to defendant at the current address provided by the defendant, and defendant shall appear in court as directed by the mailed notice. If defendant fails to appear pursuant to such a notice mailed to defendant by the court or probation department, then the court may issue an arrest warrant. And then you have the attorney's certification. I'm not going to read that. It's just saying that, to my knowledge, the defendant is legally competent to proceed, and he or she has been able to satisfactorily assist in the preparation of this case and other things. All right, let's see here. The defendant pleads guilty to actually exploitation of a child, a class 4 felony voluntarily, and is not the result of undue influence or coercion on the part of anyone. Defendant acknowledges that there are factual basis to support his guilty plea to the charges described in paragraph 1. Defendant agrees to the following for the period described in paragraph 3. Defendant shall not violate any state, federal, or local laws, including traffic violations, for which the Colorado Motor Vehicle Division would report any violations or charges to the Montrose District Court in writing within 10 days of the occurrence. Defendant shall report any address or phone number changes in writing to the Montrose District Court within 10 days of any change. Defendant shall not violate any provision of the protection order. Defendant shall pay all costs and fees as ordered to the court. All amounts due and payable pursuant to a sentence is a civil judgment and may be collected after the deferred and probation sentence have terminated. Defendant will pay to the victim's compensation and the victim's assistance fund, irrespectively of court finding of indigency. There is zero restitution in this case. Defendant shall successfully complete 4 years supervised probation. The number of hours of useful public service and due date shall be set by the court if ordered. Defendant shall abstain from excessive use of alcohol and all use of illegal drugs, including but not limited to medical marijuana. Defendant shall submit to a breath test or urine test upon the request of any law enforcement or peace officer during the term of his deferred sentencing stipulation. Excessive use of alcohol is defined as a blood or breath alcohol content higher than 0.050 grams of alcohol per 100 milliliters of blood. Defendant agrees that a portable breath test is sufficient evidence for the presence of alcohol and the level of alcohol in blood. Defendant shall complete all offense-specified evaluations and follow all recommendations. All other terms and conditions ordered by the court. Defendant shall comply with the plea agreement for this case and shall comply with any order, terms, or conditions imposed by the Montrose District Court pursuant to the plea agreement and deferred sentencing stipulation. The plea agreement has been executed by all parties and has been submitted to the court with deferred sentencing agreement. Defendant's sentencing is deferred subject to full compliance with the conditions of this deferred sentencing stipulation. Upon full compliance with such conditions by the defendant, the plea of guilty previously entered shall be withdrawn, and the charges upon which the judgment and sentence of the court was deferred shall be dismissed with prejudice. Upon a breach by the defendant of any condition regulating the conduct of the defendant, the court shall enter judgment and impose sentence upon guilty plea in paragraph 1, when, as a condition of the deferred sentence, the court orders the defendant to make restitution, evidence of failure to pay, and said restitution shall constitute prima facie evidence of a violation. Whether a breach of condition has occurred shall be determined by the court without a jury upon application of the district attorney and upon notice of hearing thereon, of not less than 5 days to the defendant. Okay, not less than 5 days to the defendant or the defendant's attorney of record. The district attorney may make application for entry of judgment and imposition of sentencing at any time within the term of the deferred judgment or within 35 days thereafter or dates pursuant to CRS 18-1-3-102. The burden of proof at such hearing shall be by a preponderance of the evidence, except as otherwise provided by law, and the procedural safeguards required in revocation of probation hearing shall apply. In imposing sentence, the court may impose any sentence authorized at the time of the guilty plea was entered, including probation. Defendant waives all rights to a jury trial and waives all speedy trial rights set forth in the Colorado Revised Statute. And there's just more info there. And then the same information is given for count 2, which he pled guilty to. So in the end, he pled guilty to 2 charges, one stalking, one actually exploitative of a minor. So now, what happens? What happens to the statement he made about being 16 and doing something similar to this? Does law enforcement look into that? Is there any way for them to prove what he did? I'm sure he's got a different phone by now. I just want it known that this individual used such extensive measures to go after his victims, the parents and the child, via messages, personal contact, telephone calls. It was sickening. This is monstrous and dangerous behavior. And it's all against his obsession of an 11-year-old little boy. And the fact that he wanted attention. So my question is, what happened in his upbringing that made him starve for this attention? Okay. What happened? Was he neglected? Did the parents not pay attention to him? Something happened that this kid was starved for attention. Why did he feel that he did not receive enough attention in life? What happened? But you got to remember, this goes back years. It had to have. So what was his early childhood like? Did he get attention? And then as he grew up, he didn't get the attention that he previously got. So he was yearning and wanted this attention from his parents and didn't get it. So he resorted to these measures to get attention from someone. Right. Really? Doing this at 16 is insane. Exactly. That's why I'm saying whatever happened to Donovan happened at an early age. You just don't start doing these things at 16. Monkey see, monkey do. Donovan has no shame. Yeah. The World is Mine says, I feel like this is learned behavior and maybe even coaching. That was going to be one of my questions. Did his upbringing have a bearing on his crimes, infatuation with other cases? Is this a learned behavior or a self-taught behavior? Or was this man groomed by other family members or someone in his life outside the family? And is this the reason for his actions? Hybrid says attention is one part of this. Actual, yep, is the other half that cannot be ignored and that didn't happen in a vacuum. Right. Yes, he is being sentenced in August, on August 26th. A little too personal info. My siblings started breaking into houses and stealing cars after all his abuse caught up with him. Roughly 17 years old. And that's when 16, 17, that's when you find your independence. And that's when those things start happening. Remember the 80s PSA? I learned it from you, Dad. Yep. Well, we all know that his dad fixates on things that he believes is the truth. Correct. So how do we spot signs? Let me get my mouse working here. How do we spot signs of these sick and monstrous behaviors of these predators? I'm going to give you the top 5 warning signs that may indicate a person is an actual predator. Okay. First one, proximity to children. Pay attention to individuals who consistently seek out opportunities to be close to children, whether they're teachers, coaches, family, friends. An unusual focus on spending time with kids can be the number one flag. Emotional dependency. Child predators often create emotional dependency with their victims. They may use gifts, attention, or other manipulative tactics to build trust and gain control over the child. Three, Manipulative behavior and language. Watch for signs of manipulation. Predators may use subtle language to groom children, making them feel special or important. They might also exploit vulnerabilities to gain trust. Pushing boundaries. Be cautious if someone consistently pushes physical or actual boundaries with a child. This could include inappropriate touching, suggestive comments, or trying to isolate the child. Okay. Jealousy and control. Predators may display jealousy or controlling behavior. They might become possessive of the child's time or react negatively when the child interacts with others. We've seen that in the documentary about the kids, the child actors. I can't think of the name of the documentary right now. We've seen all of these in that documentary. Those are the 5 biggest things that a parent or a loved one or anyone should look for when looking to see if a child predator is after them. Now, below the video in the description, I have provided 3 links. One is to a website, Keeping Children Safe Online. This website offers tips, videos, and resources for parents, guardians, caregivers, and teachers. It covers topics such as discussing internet safety, setting guidelines, and using parent controls. The second resource is Very Well Family, Protecting Against Child Predators. The Safe Side website provides resources for kids, including quizzes, puzzles, and safety tips. Additionally, the National Center for Missing and Exploited Children offers free child safety resources for parents, guardians, and children at missingkids.com. The third one is Erase Child Trafficking, online safety resources. This site provides online safety resources, guidelines, and tips backed by child advocates, law enforcement officers, researchers, and parents. These resources can help parents and their kids combat online predators and stay safe on the internet. Please check out these references and do your own research on finding more resources to help you teach your children about these situations and about educating, informing yourselves as to what can happen with these child predators. It's paramount for all of us in today's world to start researching this and keeping our eyes open and protecting all the children in the world. Somebody has to do it. It's our responsibility as adults to educate ourselves and safeguard our children's lives. Because in this community, we see too much evil and destruction when it comes to our children in this world. Somebody has to take a stance. We have these great groups and organizations out there to help us. It's time for all of the individuals around the world to take our head out of the sand and fight this together. The only way you're going to be able to do that is to educate yourself and educate your children on what to watch for. With that being said, I want to thank Carly and Honeybee for gifting more memberships. Next week, I will be having a members live. And New World is Mine. Welcome as a member of the channel. Please take the time to encourage others to watch this live stream from last night and tonight. It could mean the difference in saving their child or a child in their family. You can never be too careful, even just playing video games unmonitored, if a risk. Playing video games is the number one place these individuals go to find online victims. Not enough is done to keep predators locked up permanently. Not enough resources and laws need change. Watch your kids. Exactly. I learned about human trafficking over 40 years ago. Not anything new. It's been happening that long. My stepson was conned out of $500 on a gaming platform at 13. Yep. Thanks for sharing the info on the DoorDash diddler. You're welcome. Like I said, the reason I did this is to educate everybody. Through these 2 streams, I have been able to give you their methods, patterns, and emphasize the importance of vigilance in safeguarding children. And if I find another case study, I will definitely be bringing it to you in the future. With that being said, everyone, I hope you have a great night. I believe Fire and Ice are doing a live stream coming up here, or they've already started it. So, they're in the chat, so they must be waiting for me to get done. Go check out their channel, and thank you once again for all of your support with this subject and for sharing this information with everybody you know. Have a good night, everybody. Bye.